All right. Turning to the outstanding motions in limine. We've got motion in limine 64 and the response, and essentially, I mean, honestly, the motion in limine is basically saying, can we make sure that we follow 24/7/704, which we will. But in terms of preventing testimony short of something that would violate that statute, it's denied short of that. So it's, you know, it's not going to change any of the previous rulings about what various experts can testify to. All right, motion in limine 65. Let me look at the response again real fast. I printed those out, but I didn't bring them with me this morning. So give me a second. Actually, I think they're arriving right now. So the contours of Investigator Viverito's permissible testimony have already been established as well. And so we won't be changing the ruling on that either. And then we've got motion limine 66. Which concerns Mr. Lamar, Rich Homie Kwan, and neither side really should be able to say. It seems that the defense wants to bar the state from being able to say the defense didn't call this witness at trial, which obviously they concede they have no right to do and say they have no intention of doing, and they would not be permitted to do such. But at the kind of flip side of the same coin, the defense seems to maybe be suggesting that they would like to to present that the state could have but did not call that witness. And I would not permit that either, because we're clearly nowhere near, unfortunately, the end of the state's case. And obviously, Mr. Lamar has now passed, and so we don't know whether they would have called that witness or not. So I wouldn't permit the defense to make that kind of a presentation either. So I trust that everybody understands what they would not be permitted to do. And then we have, yes, sir.
Speak to that for a moment?
Yeah.
Thank you. Good day, Your Honor, and good day, everyone.
Good morning.
So I understand your ruling, obviously, abides by it, but what I'd like the record then to show, if you don't find this to be changing, the state sent us lists of witnesses on a short list that they were going to call Mr. Lamar, who's a performer known as Rich Homie Kwan. This was well before September 5, 2024, when he, God forbid, passed unexpectedly. So to me, and the state has put in evidence over objection that starting in the fall of 2014, Mr. Lamar and Jeffrey Williams don't get along, and Mr. Lamar's with Mr. Donovan Thomas, who doesn't get along with Jeffrey
Right.
Williams. And it's all, to me, it's all made up. It's not supported. Obviously, the jury can make that determination. But I think that it is important that the state, in writing, put the predecessor court, as well as Mr. Williams et al., on notice that they were going to call Mr. Lamar. They filed their service of a subpoena, and they don't call him to support this, supposed beef. And I can't do anything about his prior statements now because it would be frivolous under 24-8-807, which is rarely used, it's frowned upon, and it has to have the same guarantees as a dying declaration or something. It's not like that. He gave interviews throughout all the years talking about his close relationship with Jeffrey Williams. And if you let that in, that's great with me. But I'm assuming you're not going to let it in, so I wasn't going to try to get it in because I don't think that that's a dying declaration type of statement. So I'm stuck. So I would like the jurors to know that unfortunately he passed, and the state stated that they would call him as a witness and subpoenaed him. And if the state has reasons that they didn't call him, that's fine. I understand I'm opening a door, but that's why I put it in writing. That's my motion.
All right. Well, I mean, if the state's case were over with, then that would be a different argument. But it is not as though the state's witness list has stayed in anything like any semblance of order during this trial. So, I mean, I don't think that if you can get a concession out of the state that they weren't going to call him even if he stayed alive, that would also be different. But I don't think that we've got that situation.
I understand the ruling.
All right.
Thank you, Your Honor.
Okay, and then we have this issue of the state wanting the court to reconsider its ruling striking whatever day that was, that one day of the detective's testimony and the defense response. And I believe, and Mr. Armstrong, I see you standing because you might want to argue, but I think that the waiver argument that is presented in the defense response is meritorious. I think that the arguments that the state made after that they were waived because they certainly were not made at the point in time when I could have done something about it. But in addition, the state last week ended up calling a different detective and investigator, Detective Underwood, who's on the stand essentially right now in the midst of her testimony and seems to be covering the same things that the other investigator was covering anyway. So it doesn't even seem, it seems like this whole issue is moot.
May I be heard, Your Honor?
You may be.
May it please the court, Kevin Armstrong for the state. First of all, the contemporaneous objection rule, which was cited by the defense, which is the waiver argument that Your Honor referred to, is one about preserving an issue for appellate review. It is not about a court who can reconsider their rulings during trial. One of the issues that is here is that the court precluded the state from calling that individual back to testify about other things. And that's one of the things that the state filed the motion for reconsideration to avoid. And so the state is asking that for other issues and for whatever issues that have not already been addressed, the state be allowed to recall Detective Dennis to testify about other matters that were not the offending statement, which the court appropriately excluded from evidence. And one of the things the defense brought up in their response was confrontation. I want to make it absolutely clear that there was no intention in the motion for reconsideration to have state's evidence in that they didn't get the right to confront, and so that was not part of the issue. But the issue isn't only the testimony that was struck from that day, it was his future testimony, precluding him from testifying in the future. And while there are other means to get in some of the testimony, I don't believe that is all the testimony that the prosecution team intends to get in through Detective Dennis. And so essentially it's an ongoing order of the court that we would be asking the court to authorize the state to present that witness to testify further.
So tell me what it is that this other investigator or detective is not going to be testifying to because she was qualified to be able to testify to the meaning or her opinion as to the meaning of particular lyrics. So what is it that only this other witness, Dennis, could testify to?
I'm going to turn that over to the facts prosecutor.
All right.
Thank you, Your Honor. Detective Dennis testified to a statement regarding Defendant Kendrick in which Investigator Underwood was not present for that interview, and so he testified to that. He also testified further regarding the Quindarius Zachary interview in which Investigator Underwood was not privy to that interview as well. Additionally, Your Honor, he was able to introduce several additional exhibits to include the Magic City video that will not be able to come in through Investigator Underwood. And I believe those are the three primary things that Investigator Dennis was able to testify to previously that was struck that Investigator Underwood would not be able to introduce during her testimony. In course indulgence for one moment.
All right. Thank you.
Thank you.
Okay. So, Mr. Steele, I guess you sort of led the charge on this, if I'm not mistaken. What do you say to the state's position that the court's decision to strike and prevent further testimony of this witness isn't a remedy that is permitted to the court by statute or the Constitution, and understanding that if this were reconsidered, the defense would be permitted to cross-examine?
So I believe that you have the authority, jurisdiction, and power to prevent a witness from testifying when that witness shows that they are not capable of providing a fair trial and intentionally, and that's my word, but it was clear to me sitting there that when Ms. Hilton asked retired Detective Dennis, tell us about this photograph that has Mr. Kendrick standing on top of a car, his initial lead into that answer is, well, Mr. Kendrick just got out of prison. And, you know, that affects Jeffrey Williams. Mr. Kendrick, as the court may have heard, is signed to Mr. Williams' record label. Mr. Kendrick, as you will learn, is at Mr. Williams' home on May 9th, 2022, when Mr. Williams and Mr. Kendrick are arrested. And it is just not that simple to unwind that instruction. It was an intentional, obvious infliction to denigrate this trial and prejudice Mr. Williams, Mr. Kendrick, and all. So you then have to do something about it. And what you asked to do is declare a mistrial. And you said, I'm not doing that, but there will be a sanction. So what are you going to do? So to me, that was the second time. The first time the court, I'm not saying it's not accurate.
So obviously, considering that I'm the one that imposed the sanction, I think it was an appropriate sanction. Address the state's argument that a trial court doesn't actually have the authority to impose that sanction.
I think that's wrong, based upon, let me give you, and I put it in my response, but Illinois versus Allen, 397 U.S. 337, it's 1970. What happened there, and the U.S. Supreme Court took down, that was an accused right to be present at a trial, constitutional right. And there's a dissent in it saying the accused, no matter what their conduct is, they could be gagged and bound. They have to be in the courtroom and watching the proceedings. Otherwise, it's a constitutional violation. But the majority said, this is ridiculous. Courts have to have the power to ensure that the trial is, and I'm quoting, conducted with dignity, order, and decorum. They are the hallmarks of a court proceeding. And then I found a case, I just found it amazingly similar. California versus Navarrete, Navarrete. Your Honor, it's 181 California Appeal 4th, 828, 2010 case. And in that case, a detective is testifying, and there was a suppression motion granted. There was no Miranda rights given to Mr. Navarrete. And the detective testifies on the witness stand and said, well, the reason I didn't follow up on this DNA swabs is based upon the client's or Mr. Navarrete's statement. The judge did exactly what you did. The judge called the prosecutor, well, a little different, called the prosecutor and defense counsel in chambers and yelled at the prosecutor and said, you know, I'm demanding, what are you doing? And the prosecutor said, I didn't know that that would happen. Just like here, I'm not saying that it was Miss Hilton eliciting that on purpose. I had no information that she would ever do that. But the judge said, well, this detective knows better. I find the detective is trying to harm this trial. The detective is barred. His testimony is struck. The direct is gone, and he can no longer testify. And the state did exactly what happened here. The state in California, the prosecution, the people, they called the next witness. To me, it's on all fours. The appellate court, Mr. Navarrete is, God forbid, convicted, and the appellate court then reversed and said, that remedy did not go far enough. That had to be a mistrial, that intentional conduct. And here, I'm asking the court, I believe that you have total authority. There is no way that anyone will convince me, I'm not the one who needs to be convinced, that Detective Dennis did not realize. It came out of nowhere. What difference does it make that Mr. Kendrick was released from prison 5 weeks earlier? What difference does it make? He did that to bring out to the jury that Mr. Kendrick was in prison for, and I'm telling you, it's a federal offense. There's no basis. So to me, to say you don't have the authority to do that, I believe you have every authority. If a witness comes in here and starts cursing, I'm using an example, I would assume, you are going to say, you know, this is just not decorum. You can't curse. The witness curses again. You're going to do something. You're done testifying. Courts have that power. So I believe that the state's argument that you have no power to control the proceedings is not backed up by the U.S. Supreme Court.
All right, thank you.
May I respond?
You may.
There was a defense attorney who raised their hand.
Good morning.
Good morning, Your Honor. I want to be very brief because I don't think what I'm going to add is truly what Your Honor is looking for. But
Jay Apt, Your Honor, good morning, on behalf of Mr. Kendrick, and I'll try to be extremely brief. Your Honor decided this issue in lieu of granting a mistrial, and one of the things I want to remind the court, really I'm just here to remind the court, is one of the reasons for this sanction, Your Honor, is because of, and I'm not pointing fingers at any particular district attorney, but the state's repeated unpreparedness, their repeated discovery abuses, and so this is a compound issue. And I think my perception is that the court finally had to say, okay, we're not granting a mistrial, but we got to do something. And if you now go back on that decision and reverse your own decision, you are essentially creating an incentive for the state to continue these, I'll call them mishaps, whether they're negligent or intentional. And I think the court has sent a clear and convincing message to the state that they need to be buttoned up, more buttoned up than they have been. And so I would ask the court, certainly the court has the authority, and Mr. Steele has done a very good job of explaining that, but I would ask the court to uphold its own decision to send that loud and clear message. Thank you, Your Honor.
Thank you. Mr. Armstrong.
Yes, Your Honor. I would agree with Mr. Apt to the point that I would like the court to uphold the determination that the court made, which was that it was not an intentional, willful act, as Mr. Steele has argued. I want to address both of the two cases that he referred to, Illinois versus Allen. One of the issue in Illinois versus Allen was a defendant who refused to act with decorum and was excluded from the courtroom, but was permitted to come in the courtroom if he was going to behave correctly. And so it went specifically to the offensive behavior for as long as the offensive behavior went on. We are asking the court to, the court appropriately struck the testimony that was at issue. We are asking the court to go further with other testimony that was not the offending testimony. Now, People versus Navarrete is the only case the defense has cited to suggest that this specific remedy was permitted. That is a nationwide search in People versus Navarrete, Navarrete, is the only one that they were able to cite, and that is materially different in a number of ways. Number one, the facts are wildly different. The officer in the case was mad at the judge for excluding a statement that the officer had obtained, and actually had told people that when the prosecutor found out, told the judge after the fact, when they found out, that the officer had basically said he was going to do this because he was mad at the judge and would show the judge what for. That is not anything what happened here. And the reason that the appellate court in California decided that a mistrial was necessary in that circumstance was because of the specific evidence in that case, which is basically three things. You had a witness testifying the defendant had committed lewd acts against them. You had somebody testify they took about, I think it was a dozen or more swabs relevant to that. And then you had the officer testify, oh, I didn't think it was relevant to get the swabs because of the statement the defendant made that I can't talk about. The officer specifically said that because it would prejudice the defendant. And those are the circumstances in which it would, in fact, be incapable for a court to take that away. I would note before I go on to my main point about People versus Navarrete is that the California appellate court stated, we note that a trial court can almost always cure the prejudice of an improperly volunteered statement by granting a motion to strike and charging the jury with an appropriate curative instruction. This court did exactly that. It was just the exact facts, how thin the state's case was on that issue, on basically the entire case, and the reason for it was why they decided a mistrial was necessary on appeal. More importantly, this is the case that they cite that says the remedy of preventing Detective Dennis from testifying further. This is the case that they use for that proposition. At no point in this decision does the appellate court address the legality of that. They simply don't do it. It is not addressed whether that was a legal remedy to occur. It's not something that stands for the proposition that the defense is citing it for, which is that the remedy to prevent Detective Dennis from testifying further is appropriate. And so they have not pointed to any statutory or constitutional authority, and under Rule 402, the exclusion of evidence can't exist outside of that in the state of Georgia. Now, I'm sure, let me just strike that. So we're just asking that the detective be able to testify further in the case when the prosecution team determines that he is the person who's best able to testify to facts that are relevant for the jury's consideration.
All right, thank you. So I don't think that the facts in the California case are really that different than the facts here. Frankly, I think that an argument could very plausibly be made that the detective in this case was upset with somebody about his qualifications having been challenged and had made a decision that he was going to show somebody what he thought about that. I don't know that that's what happened, but I do think, like I said before, that the detective absolutely knew better than to have said what he said and did it anyway. And I have given consideration to everything that has been presented, but I am not going to change my decision about this. All right. I think that the next thing that we had to do was sort out the remainder of what we're calling the Ryan evidence. So if y'all want to present what you've come to agreement on and what still needs to be litigated. And thank you, Mr. Armstrong.
Thank you, Judge.
Yes, Your Honor. And one small matter that's in this act we can address is in the CAD report. Okay. Never mind, Your Honor. Counsel and I have been discussing stuff frequently. So
Yeah, I know.
I will turn to all that's left to my understanding is the last little bit of Blaylock's Instagram.
Okay. And do y'all want to give me some kind of, I don't know if it's written or whatever, indicator of what y'all have agreed to, or just put it on the record, or? what's in, what's out.
Your Honor, I'm trying to think.
Or I guess, if you don't have something at the ready, then I would assume y'all are on the same page about it and will abide by whatever it is you agreed to.
Your Honor, I believe that is accurate.
Okay.
I think what the state would be moving to enter into evidence is things that we've agreed upon or the court has already ruled on,
Okay.
besides what it is we need to discuss this morning.
Okay, all right. And so what is it that needs to get discussed this morning?
This morning, Judge, we're going back to content in Mr. Damone Blaylock's Instagram messages between him and third unknown parties. Your Honor had asked me to take a look as far as co-conspirator hearsay.
Okay.
From what I can tell, every instance I've found requires evidence really from the outside, that basically you could ignore this entire statement and there's still something to indicate participation in the conspiracy. I don't have any sort of law stating one way or another that that is what is required. I would just point back to the statute, Your Honor, that I think what Your Honor had referred to, I would say kind of are indicia of reliability, that they're talking about things that a person who's a member of the conspiracy would know about, and just simply that's not what's articulated in the statute. If it was supposed to be indicia, then I think we would be there, but that's not what the statute requires, so I don't think that would be sufficient. I think it truly does have to be from outside of that hearsay statement.
All right, and is there further argument from the state on that? And I know there was one, and there might have been two that we had already looked at that were kind of outstanding, and I had given a preliminary ruling subject to further argument on this. And the second one, I think I already brought up, and I don't know, Ms. Abbasi, if you were here that day, but that I didn't think there was enough, so I have excluded that. But the other one, does the state have any further argument or authority on that?
So, Your Honor, I don't have, the state's argument was in looking at 801 D2E, just the basic building blocks of if the court finds through the four walls of a statement, evidence in trial, or some other evidence the state would present. Ultimately, it is the court has to find that that other party, whoever they are, to a preponderance, are part of the same conspiracy against who it's being used against. And I will use, I don't have a specific case for this principle, but I think it illustrates this point the state is making, is if you take aside a gang conspiracy, say you had a murder committed, and the defendant's phone, they get a search warrant, they extract it, and he is messaging someone after the murder that you do not know who they are, and he says, I need you to go to my house, the murder weapon's in my back bedroom in the second drawer, and they respond back, yep, the police, I can hear the sirens coming down the street right now, I'm going to go grab that gun, where do you want me to take it to? And they have this whole conversation. You don't never know who he's speaking with. By my reading of, or an understanding of co-conspirator, that conversation, if you had it in that trial and were trying to introduce it, I believe a court could find from the four walls, so to speak, of that conversation that that person they're speaking with to a preponderance is a co-conspirator. And by that same analogy, if you have in the conversation that the unknown party, so to speak, whether it's their Instagram handle, the fact that they're referencing specific individuals or that gang APD detectives have referenced are, say, YSL members, or they're discussing locations, or they're using gang identifiers in a private conversation, coupled with the evidence that that hasn't came in yet because no evidence about Blaylock to the jury has came in, but, when APD gang detectives to speak about Blaylock and his Instagram in public and private conversations indicative of his own membership in the YSL criminal street gang, all of those the court can use or not use in making that determination. And so I don't have a seminal case that says you need more than the statement itself. I think oftentimes the statement itself, absent this kind of, in a gang context, there's other information versus when you have just, say, a murder case, you would, other than the factual analogy I just gave to the court, it would probably be hard to decipher. If you just had a single text with an unknown party, you wouldn't know who they are unless it was like the analogy I used. So the state doesn't have any additional case law. I always will cite, because I think it's a seminal case and important for a criminal street gang conspiracy, which all of Blaylock's are, the state's arguments related to them are not tethered to the murder of Jamari Holmes. They're tethered to the YSL criminal street gang, at least the ones that are in dispute, I should say.
All right, so can somebody remind me where it is that we're going to find the statement specifically that we had been paused on before?
I don't know if this, I'm sorry, excuse me. I don't know if the state sent to the court a new link or we're still
I'm
on
sure
the
there was
prior
a
one.
link that y'all sent me at some point.
I can create
Over and over again, I know, I'm
Yes.
sorry.
for a
Most recent one, I
If
don't
you
know.
wanted to just remind me when that was, I could probably find it, or
The-
what folder it was in.
Yes, Your Honor. The initial folder was 9 October centralized motion folder in Dropbox. For efficiency's sake, I can
Okay.
quite quickly create and
That would be
send.
wonderful. A new link.
Yes, Your Honor.
Okay. And I guess it'll be easy enough to see once we're all looking at it again. But I cannot remember whether in this particular one that we were talking about, there was anything like the other speaker's handle or anything like that that would have been outside of the statement itself. So I guess when we get the link, we can look at that.
And Your Honor, I'm going to try initially to email because Blaylock's Instagram is 28-page PDF. So I think that that should be small enough to send via email.
Okay.
That email has been sent, Your Honor. I utilized the Zoom link email that Ms. Percival had sent. If anyone does not get it, please let me know.
Okay, thank you. All right, so it was at some point after the 293 one. It may have been the one directly after that.
Your Honor, I
Yeah.
believe we had the court's preliminary ruling of admissibility pending additional case law from defense ended on 344.
Right.
And so there's only, I believe, 5 PDF pages left for
Okay.
Blaylock. And so it will start in PDF page 13, Instagram page 359.
Right, but my preliminary ruling pending the additional case law is still a preliminary ruling. And
Yes, Your Honor.
so the conversation, if you will, that starts on
342.
342 and goes through 44?
Yes, Your Honor.
Okay, that's the one that it was only a preliminary ruling. And so the person whose true identity is unknown, is their handle Snake Life Maniac?
Yes, Your Honor.
Okay. All right. And did I understand your argument to be that the court could take into consideration in determining something outside of, if there's anything outside of the statement itself or the conversation itself that would indicate kind of a co-conspirator nature, that the court could and should take that into consideration?
Yes, Your Honor. And what the state's referencing in regards to that is the totality, specifically or almost exclusively from APD gang detectives, which started with Detective Belknap, the first witness in the trial, in terms of, like, for example, and there's also, they're discussing, someone references Pokey, which has come up periodically in this trial and is one of the individuals that Quindarius Zachary mentions was participated in the shooting of Miss Reed's home, right, when he's discussing Kenneth Copeland returning. And also when this Snake Life Maniac, when Blaylock, who's one King DO1, states he was stamped into the street gang by Pokey, the individual responds, he's been locked up a good 6 to 7 years. When did you get stamped? And he's kind of checking to see if that story checks out. And so the state's argument, and then it of course continues on, but and the Snake Life Maniac says, I never met the young rock crew. There's been a lot of testimony about rock.
Right, but if I have to find something outside of the statement itself, then that would indicate, I think, that I can't take into consideration the contents of what this unknown person is saying to make that necessary determination, right? So
The state's understanding and argument is that you can use, whether it's this statement itself alone, the court just has to find to a preponderance that this
well, we
individual
know
is
that the statement alone can't establish the existence, or I'm sorry, the participation of the declarant in the conspiracy. I mean, that the statute itself provides that much information.
And I guess my argument, Your Honor, is that the testimony in trial is in addition to the statement. As in, like, if you just had this in a vacuum and I presented no other evidence of why what they're saying is significant, if you didn't have APD gang detectives who've testified about what these indicate or mean.
So because we have outside of this statement testimony about Pokey and testimony about how people get included in gangs and things like that, is
Yes,
that
Your Honor.
your argument?
That's the state's
And in
argument.
addition to that, this person's handle itself indicating their connection to YSL?
Yes, Your Honor.
All right. Okay. A preponderance is really not that high of a standard burden to meet. So I am going to find that this one does meet that. outside of the statement alone, so that entirety of that can come in. So we then need to move on to whatever was left. Is that right?
Yes, Your Honor.
Okay. All right, and so the next one would be on page 430, or are there some that y'all have?
359, Your Honor.
Oh, that's a different one? Yeah,
It's a different one.
Yes, okay, so 359.
So what's highlighted is Blaylock stating you have to pay the dues January 15th. That's the day you got stamped. And then the individual responds back essentially like he will pay him when he sees him. The state, because this conversation is so brief in terms of comparatively to the one before, the state will concede or not utilize 359.
Okay. So y'all will withdraw that one.
But with yes, Your Honor, 430. So the individual that Blaylock is messaging, YSC Prince, he says he's leaving that YL up to you and me. YL is Young Loyalty. So when YSL, the criminal street gang, you have remnants of, Young Loyalty is essentially a subset of that. And so when he said he's going to leave YL up to me and you, he said when he gets out, it's still going to be YL, but we're going to take it over, basically. Let's push up next weekend. The state wanted to include that because of direct reference to Young Loyalty and someone having to take it over. This would be in conjunction with, which I don't believe or do not recall, testimony thus forth in trial, as in through Detective Belknap, or will be when Detective Viverito testifies about Young Loyalty YL. But that was the state's request or argument in terms of this would have to be, the court would have to deem YSC Prince making that statement is in furtherance of the conspiracy to admit this as an exception to hearsay.
Okay, and you're saying we don't thus far have any evidence about YL or the meaning of YL, and are we going to get any?
Your Honor, yes, the state, I am drawing a blank if Detective Belknap addressed that when he first testified in this trial. I just do not recall as I'm sitting here. But if he had not, the state would proffer that Investigator Viverito would discuss that at a future date. I do not have any additional evidence.
And YL is, how is YL furthering this conspiracy? I'm not following your argument. I'm sorry.
So Young Loyalty YL is a part and parcel of YSL. It's like a subset. And so the state, by him saying we're going to take over specifically YL, that is trying to assert leadership over Young Life, or Young Loyalty, Your Honor. So
that one seems a bit, I don't know, far afield.
Understood, Your Honor. The state will not utilize
all
430.
right.
And
Okay.
the last one, Your Honor.
Can I, Ms. Atkins, do you mind if Your Honor, can I just interject?
Sure, I mean, they're withdrawing it and or I'm excluding it, but, so do you need to?
No, I thought it was still up in the air.
All right, so 2145.
And Your Honor, the last thread of this nature is when you go to page 446, there's just one line where Blaylock is discussing, he says, "You're not slime," and on 447, they go back and
I don't see a 446, 447.
it is PDF page 15, Your Honor, and PDF page 16.
Okay.
And the key, the statement that the state is seeking to introduce is when Blaylock on page 447 states, "I stamped you in slime behind the Blue House," talking about bringing that individual into the gang. The 446 is only included for brief context to that. The state would not necessarily have to use 446, but the argument is that when Blaylock states, I stamped you in slime behind the blue house to this individual when they're going back and forth about if that individual is slime, that statement, the state believes there's two arguments for this statement in terms of Blaylock definitively stating that he brought this individual into a criminal street gang, and he references the blue house of just a specific location to remind him where he stamped him in. That statement is a co-conspirator statement, but in addition is a statement against interest. And the best example of why it's statement against interest is the case of this nature. And if Blaylock was in this physical courtroom right now, that statement he made there is against his interest in terms of definitively asserting he has enough rank in a street gang to stamp someone in, and would be evidence that could be used against him in a criminal street gang or RICO predicated on a street gang trial. And so the reason that the state articulates that this is 801D2E is because when he's telling someone, you know, I stamped you in slime behind the blue house, it's a conversation between, he's asserting in this statement that he brought this person in the gang. And so those kind of conversations, they have to be able to speak freely amongst each other, and they're discussing criminal street gang activity in terms of he's referencing when he brought him into the gang. And given the liberal standard of admissibility from Kemp and its follow-on cases, and that fostering cohesion, also, you know, the direct reference to the exact criminal street gang conspiracy that the state is alleging they are a part of, feels that Blaylock's statement, I stamped you in slime behind the blue house, should be admissible under either of those two bases, Your Honor, is the state's argument for why it's not hearsay.
All right. Why? I think that one passes muster. Yes, sir.
I believe that a statement against the penal interest, as articulated by the prosecutor, if it only goes to Mr. Blaylock, that we would get a limiting instruction.
I think it comes in as a co-conspirator exception. The I stamped you in slime behind the blue house.
Okay, and understand the court's finding, then I would ask you to decide whether 24-8-805 hearsay within hearsay would apply, because I don't see the exception on the other end of the conversation. I don't see I stamped you in. The other person's statement is also 801D2E.
The other person's statements, frankly, are GMFU and you not.
So how did
I mean, I don't
that conversation
think
further
it
interest?
seems, I don't think it does, but I don't think those statements are being offered for their truth.
That is correct,
All right. All right, so what's the next one?
Your Honor, that, and correct me if I'm wrong, Ms. Bossi or Ms. D. Williams, but all of the remainder of this are conversations we have discussed that are pertaining to the February 23rd, 2019, the night of, day of the murder itself, not gang co-conspirator statements. They're tethered to, they're ones we've discussed of no issues with. Unless
Okay.
defense counsel corrects me.
That's right?
Accurate.
Okay. All right, and so is that it for
That's the entirety of Mr. Blaylock.
Ryan evidence? All right, and when are we, you know, we discussed before about how we need to get to this kind of grouping of evidence before the end of this month. Is that going to happen?
Your Honor, there is a, yes, Your Honor, the state, we could reach this case today.
Okay. All right, sounds good then. And then how about the Mr. Arnold scheduling? Is that gotten nailed down? Okay.
was in his folder, Your Honor.
Making sure.
I didn't know that we had gone through all of his Instagram posts. I don't know that all of it will be relevant, although it depends on what he says on the stand. I don't know if the state would agree or disagree with that.
Sure. Just want to sort out what we can while we've got time beforehand and not have the jury waiting, because Lord knows they have to wait on us enough as it is. All day today we're waiting on them. Where did Misty Williams go?
This is the restroom.
Okay. What? Can we get the state in, please? All right, I assume we're going to be picking up with Detective Underwood? Okay. All right, if you want to go ahead and get her on the stand, we're going to get the jury out. Unless, let me ask, is there anything anybody needs to put on the record before we get the jury out and start with testimony again? Nope. Nope. All right. Okay, let's get Detective Underwood. And we can be getting the jury out as well. All right, the jury's going to be coming out also. I don't know. Sorry, I didn't write it. You know what? It's probably on this witness. Oh, you know what? Detective Underwood? Oh, maybe Mr. Abadi's getting her? Yes. Yeah, no, he went out to get her. Good afternoon. Sorry to keep you waiting around. All right, thank you. Everybody can be seated, and we're picking up with Detective Underwood's testimony.
Good afternoon, Detective Underwood. How are you today?
Good.
Good. All right. As soon as Ms. Knight gets set up, we're going to start with some defense exhibits that I want you to look at. Let me ask you this while we're trying to do this. Last week, you said that that some of the violence died down in about March of 2015.
Yes.
All right. I'm going to show you what's already been admitted as defense exhibit, Mr. Williams, number 19. Do you see what the cover of that says?
Rodeo tour,
And what's the year?
2015.
And I'm going to flip to, I believe, page 3 of that exhibit. What does that say?
Tour schedule.
All right. And can you tell Judge roughly when did that tour begin?
Look like Saturday, February 28th, 2015.
And when did it end?
Maybe it's the last date on this page is April the 3rd, 2015.
And prior to today, had you heard of this tour?
No.
Do you know Mr. Williams was featured on this tour?
I don't know. It just says rodeo tours, but I don't know who. It don't say who was featured.
I want you to go back to that tour date page.
Okay.
Do you see a stop on that tour for Houston, Texas?
Yes, March 23rd, 2015, Houston, Texas.
All right. I want to show you what's already been admitted as State's Exhibit 418Y. When you look at State's Exhibit 418Y, do you see the caption on that picture?
Yes.
What is the caption on that picture?
We in Houston with this S word.
Okay. And are there emojis next to it?
Yes.
And are you able to tell what those emojis are?
Snake emojis.
All right. And what's the date and time of this post?
9:43 p.m., 3/22/2015.
Okay. And in looking at that post, are you able to identify any of the individuals in that post?
Yes.
Okay. If you can, permission for witness to step down?
Yeah.
All right. And using this, the monitor board, you can just tell the jurors.
There should be a pointer somewhere and a laser
Oh,
pointer.
I got it. Just who you are able to identify in that post.
Demetrian Darlington, Anastia Webb, Kelvin Treadwell, aka OG Bidley, Fontavious Stevens, aka Tick, Jeffery Williams, aka Young Thug. That's Demise McMullen, aka Nard. That is Antonio Sledge, aka Wintu. I'm not sure which sister this is. One of Williams' sisters. I don't know which one. He has a couple. I don't know who that is or what that is.
Okay. Thank you. And did you say that the tour made a stop in Houston around that date?
Yes.
So based on this picture and the tour dates, is it fair to say that at least for this date in March, some people associated with YSL was in Houston, Texas?
Yes.
Now I want to go to what's been marked as defense, I think Williams 220. And what we're going to do is we're going to scroll through Defense Exhibits 220A through XX. And as we scroll down, I want you to tell me the dates that are in January. Okay. And as you're looking at the dates here, and you can slow down a little. As you're looking at the dates, are these dates, let me know first, do they appear to be in chronological order?
I can't tell. My screen
Is
is not.
there a paper copy of this exhibit?
Right.
Would it be easier to let the witness look at the paper copy?
Well, unless I can make my screen a little bigger, because it's kind of minimized. And as I'm looking for the paper copy, if it's easier to turn around and look at the bigger screen to see if you can see the dates on the bigger screen. I mean, I can see the date on here. It's just the actual window is not as big, I guess.
That's as big as it is on anybody's.
Yeah, that part is not. Is that all? Yeah, that one needs to be bigger. But are you able to see the dates on the flyers? I can. Okay. We'll just keep scrolling until I can find the paper copy. Okay. They appear to be in chronological order as well. Yes.
Well, it's fine, Ms. Hilton. Y'all sorted out the issue with her
Yeah,
not being able to see.
I can see the dates on the flyers. It's just kind of smaller than what it probably should be. And are these flyers now in the month of November? Yes. And now these flyers starting in December? Yes. Are we now in January? We are in January. Okay. Is this the first one in January? Yes. What's the date of this post? January 18th, 2015. And sorry, going back to this post, where is this show located? Supposed to be performed? Like I said, Tampa, Florida. At the bottom, maybe. Okay. Is this another one in January? Yes, January 21st. And is that in 2015? Yes. Where is this supposed to be performance? She move it up a little. It look like Santa Ana, California. Are we still in January? We in February now. Okay. And I just want to keep scrolling down, see if we see anything else for January.
No, it's still February.
Now, I asked you earlier about the rodeo tour, remember?
You did.
Do you see Defense Exhibit 220 KK?
Can she roll it up just a little, maybe? Okay.
And remember earlier I asked you who was on that tour?
Okay.
Who's on that tour, that rodeo tour?
Travis Scott and Young Thug.
And that's the same tour that's in the book that we just referenced a few moments ago?
Yes.
And where the group was in Houston, or where the tour stopped in Houston in March of 2015?
Yes.
Now, are we in March?
Yes.
Okay. Are we now in April?
Yes.
And are we now in June?
Yes.
And is that the 220XX, that the last of the exhibit? Okay.
Yes.
Were the only two January flyers January 18th and January 21st, 2015?
I think so.
Okay.
It wasn't very many January.
All right. Did you see any flyers for January 11th, 12th, 13th, 14th, or 15th?
No.
Did you see any flyers in Miami for the 11th, 12th, 13th, 14th, or 15th?
No.
Have you ever been to Tampa, Florida?
Yes.
Have you been to Miami, Florida?
Yes.
Do you know about how far the distance is between Miami and Tampa?
I haven't driven them. I know from Georgia, where my house, south of Atlanta, it was like 10 hours when we drove to Miami, but I have driven to Tampa, it was like 6 hours.
Okay. So from Atlanta to Tampa was 6, from Atlanta to Miami was 10.
Right.
Now, in 2015, immediately following the death of Donovan Thomas, were there social media posts that appeared to threaten members of YSL?
Yes.
Can you describe to the jury the type of posts that, those types of posts?
Objection. Hearsay, best evidence rule.
Sustained is the best evidence.
Have you seen pictures of those types of posts?
Yes.
Permission to approach?
You may.
I'm going to show you what's been marked as Stacey Exhibit 546 Yankee. Do you recognize Stacey Exhibit 546 Yankee?
Yes.
How do you recognize Stacey Exhibit 546 Yankee?
I recognize it because back during the Operation Planners investigation, we actually had a war room at APD.
Your Honor.
See the terminology? Don't take anything from the fact that they called it a war room.
It was like our meeting room.
I understand.
And we put all our pictures on the wall involving the Operation Planners investigation. So we would collect social media posts and we would put them all that was related to the actual investigation on the wall. So we had this particular one on our wall.
Okay. And does that appear to be a fair and accurate depiction of one of the posts that you had on your wall.
Yes.
Your Honor, this time to say what I intend to say to exhibit 546Y into evidence.
Object under foundation and authenticity. Just because it's put on a wall does not mean where it was posted or found.
All right, sustained, but you may establish a foundation if you can.
Was this, where were these posts?
On social media.
Okay. And was there a particular name or social media account that were posting these type of threatening posts?
Yes, it was named.
It's a reading from a document, not an evidence.
Sustained.
Was looking at that refresh your memory as to what the name of the post was. Just look at it, if it refreshes your memory, look up when you finish.
Okay. Yes.
Okay.
The name of the actual account was Death to the Stake N-words.
And were there multiple posts on that website that you all gathered back in 2015 from,
Yes.
from that website? And is that one of those posts?
Yes, it is.
All right.
Your Honor, I'm going to maintain my objection, which was the same as Mr. Steele's, regarding the authenticity and foundation behind these posts.
Okay, overruled at this point. Go ahead.
My objection is we're talking about the collective, we did this, we did that, and I don't believe that this witness is the proper foundation for these posts. I don't believe this witness collected them.
Did y'all work together as a team to collect or view social media in order to assist with your investigation in this case?
Yes, we work as a collaborative group between Atlanta PD Gang Unit and ATF.
And as a part of this, is this one of the posts that you saw on social media at the time in which you all were investigating Operation Planters?
Yes.
And was this pulled from the site that you saw on social media?
Yes.
All right, it's admitted.
Permission to publish, Your Honor.
You may.
And what was the nature of what the post would say? So not specifically, but what was the nature of the post when you all were pulling? And let me answer that question. What made this of interest to the Atlanta Police Department?
I'll object to that phraseology. First, it would be hearsay, and then talking for other people.
Sustained.
What was the nature of the post?
The nature,
Overruled.
actually, there were threats coming in right after Donovan Thomas's murder from this particular social media site, and it was towards only members of YSL. So it was significant for that reason.
Thank you. Now, after 2015, did you all continue to look at social media even after 2015?
Yes.
Specifically, I want to direct you to 2019. Did you have the occasion to look at a post of an individual standing on a car?
Yes.
Permission to approach?
You may approach the witness freely.
Thank you. I'm going to show you what's been marked as Exhibit 3TT. Without telling me what is contained in the picture, is that a picture that you've seen previously?
Yes.
And where did you first see this picture?
On social media.
And
Your Honor, I'm going to object to the authentication and foundation of this photograph. I don't think that this detective has the personal knowledge of who took the photo, who posted it. Whoever posted the photo should be the one laying the foundation.
Overruled. Go ahead.
And specifically talking about the picture itself, what was of significance, without saying what's in the picture, what was of significance of the picture itself?
Significance was disrespect from one gang to another.
Okay. And
Your Honor, I'm going to object to that response and ask it to be struck. That is beyond 24-7-704B. Talks about the
Sustained.
As a gang investigator, what was of note in that exhibit?
There was a individual standing on a vehicle.
Okay. And the vehicle, who did it belong to?
Objection. Calls for speculation.
If it's within her knowledge, don't speculate.
It was Rayshawn Bennett's vehicle, YFN Lucci.
Okay. And the person on the vehicle, were they a member of, okay, were they associated with a rival gang of YFN Lucci's?
Yes.
Okay. And
Objection, Your Honor. There's been no foundation laid for how this detective has knowledge about someone's belief.
Actually, yeah, there has. Overruled.
And it was that of note when you all first saw this picture back when you first saw it?
Yes.
Your Honor, this time the state would like to admit Stacey Exhibit 3 TT into evidence.
3 TT?
Yes, Your Honor.
Right, it's admitted.
Permission to publish.
You may.
Now, looking at Stacey Exhibit 3 TT, is the car that you were just referencing this blue Maybach?
Yes.
All right. And was it of note of the individual standing on the vehicle?
Yes.
Okay. And do you know who that individual is?
Diamante Kendrick.
Okay. And again, was this posted on social media?
Yes, it was.
All right. As a gang expert, is there some significance of a person associated with YSL standing on top of a vehicle with someone associated with YFN?
It is significant.
I'll object under 24-7-704B about the significance of somebody's mental state.
All right, I don't understand it to be asking that question. Overruled.
What, if any, significance is that as a gang investigator when you see a post such as this?
It showed like I said earlier, the disrespect between, I felt like that this particular,
In your opinion,
in my opinion, this is a sign of,
Just a second.
okay.
Your Honor, it's also calling for her to have.
She's been qualified as an expert,
I understand, but she's just because she's an expert doesn't mean she knows someone else's mental state.
and she's not testifying to their mental state. Overruled. Go ahead.
Working as a gang investigator and dealing with different actual rivalries and, you know, the gang problems that we have had in the city. When we saw this particular post, we saw that it was like a gang member taking a shot at another gang member by standing on his vehicle outside of one of our malls here in Georgia.
and what mall was this?
Lennox.
Okay. Now, we've spoken about this term gang culture. Can you just briefly explain to the jury, when we talk about gang culture, what, if anything, are we referencing when we talk about that term gang culture?
I think of gang culture as the behaviors, the actual gangs showing their characteristics, may it be whether they're displaying their hand signs, their colors, their tattoos, and just their way of life as gang members.
Can music be a part of gang culture?
Yes.
How?
A lot of the gang members, especially here in Atlanta, uses music to express themselves. They kind of, you know, talk about where they came from, how they came from it, things that they've done, their lifestyle in the music.
Do gang members sometimes use music to promote violence and fear of their gang?
Yes.
How?
Hypothetically, if gangs are beefing and even if they're local and they know that they listen to each other's music, they would take a shot one gang would take a shot at another gang by saying disrespectful things or just letting them know that they are actually targeting them or talking to them through the words that they use.
Do gang members use music to promote allegiance to their gang?
They do.
How?
They brag about their gang. They glorify their gang. They glorify their gang members. They show the, like you said, alliances. It could be a blood gang that's, you know, really, really friendly with a Crip gang here in Georgia, and they will actually shout them out in music.
Do gang members use music to send messages to rival gangs?
They do.
How?
They send messages, you know, indirectly, maybe directly, just, you know, they might say, you know, I saw you at the club, or I jumped you at the club, and you are this gang, and they might call out that particular gang in the song, or they may not.
Do gang members sometimes use music to send messages to other members of the same gang?
I just want to note as a waiver of objection under 704B. I believe this is all a person's mental state.
All right, I don't think that anything I've heard so far is in contravention of 704B. You may have a continuing objection.
Do gang members sometimes use music to send messages to other members of the same gang?
Yes.
And do gang members use music to send messages to promote cohesiveness?
Sorry, Counsel, could you slow down reading?
So sorry. Do gang members use music to send messages to promote cohesiveness with their fellow gang members?
They do.
In your experience, what genre of music do gang members use to promote their gang?
Just from my experience, being here and working here in Atlanta for over 30 years, I've only seen the gang members use rap music.
Does it always have to be rap music?
It don't always have to be, but that's what I've seen over my career.
As a gang investigator, do you focus on music and hope that it leads to an investigation? Or do you focus on the investigation and it may lead to music?
Sustained.
I'll ask first. As an investigator, do you focus on music?
No.
What do you focus on?
The crime at hand and the actual person that committed the crime.
And are there times in your investigation that music may become part of your investigation?
Yes.
How is that?
Because if it's a particular person that was maybe a singer or a rapper or whatever that may have committed a crime, that us looking at the crime, me looking at the particular crime will kind of lead me back to the music portion, or if they're a rapper, or if they, like a lot of gang members here in Atlanta, they call themselves rappers, but they're like studio gangsters, or they just put music out on YouTube. So even if they're not as big as most rappers, we still pay attention to what they're saying, the drill music that's going on, and because a lot of time it does lead to violence.
And you said drill music. What is that?
Drill music is kind of something new where the rappers, they kind of talk about, they rap about violence, and they mostly target, you know, the rival or the ops in that particular music. And it's really fast and really, you know, they actually, like I said, talk about violence, talk about firearms, talking about drive-by shootings. And that's been popular here in Atlanta as of recent.
And as you're listening to the music, are you, in your mind, thinking about your investigation and whether or not there are particular words in the music that match your investigation?
It depends. Every investigation is different. So if we do listen to it just to see if we can get any kind of, I guess, maybe confessions. Sometimes it's confessions in music, or any kind of thing that is said that relates back to our investigation.
Okay. Now, as an expert, I want to ask you a couple hypotheticals. If you heard a gang member sing a country song, about putting 100 rounds in a Tahoe. And that song comes out a year after a rival gang member was gunned down while standing near his Chevy Tahoe. And that Tahoe was hit multiple times with bullets. Would you consider that song in furtherance of the gang that gunned down that rival gang member?
Sustained.
Would that be consistent with something that's in furtherance of the gang? Not if you say
Overruled.
Like I said, each case is different, but if a country artist did do that and that country artist was a gang member, then yes, we would look at that gang member furthering the gang in that particular song.
What if a gang member had a calypso song where he said, I shot at his mommy, now he no longer mentioned me. And there was some information that members of that particular artist's gang shot at his rival gang member's mother's house. Would that be something that you would look at as being consistent with furthering the gang?
Same objection, Your Honor.
Overruled.
The element of the offense.
I'm going to check this count on question.
Overruled.
Yes.
Now, when you're listening to songs, if they come up in your investigation, will the entire song be disrespect or have words of cohesiveness, or would it be portions of the song? What has your experience been when you were listening to the music?
My experience is it's not the entire song. It might be a verse, or it might be just a line or a couple of words or a few words.
In preparation for your testimony, were you asked to review 3 songs in preparation for your testimony?
Yes.
You're welcome. I'm going to show you what's been marked as State's Exhibit 535 Y Alpha, 539 Y Alpha, and 537 Y Alpha. And tell me if you recognize those as the songs that you were asked to listen to.
Yes.
Okay. First, starting with 535 Yankee Alpha. What is the name of that song?
Slime, S-word,
And who is the artist?
Young Thug.
Now looking at 537 Yankee Alpha, what's the name of that song? Excuse me, 539 Yankee Alpha.
539 is going to be Just How It Is,
And who is the artist?
Young Thug.
And then looking at 537 Yankee Alpha.
It look like it says Juice WRLD, Bad Boy featuring Young Thug.
Your Honor, this time the state would like to tender and admit State's Exhibit 535 Yankee and Yankee Alpha, 539 Yankee and Yankee Alpha, and 537 Yankee and Yankee Alpha.
What are Yankee? Because all she's testified to is the Yankee Alphas.
The actual song. So it was 535 Yankee, the song that you actually listened to prior to.
Yes.
Okay. That's true for each of those.
It's 537 Yankee, the actual song that you listened to.
Yes.
And it's 539 Yankee, the actual song that you listened to.
Yes.
Your Honor, I just want to say what like the 10th and the mid. Stacey's exhibit 535 Yankee and Yankee Alpha, 539 Yankee and Yankee Alpha, and 537 Yankee and Yankee Alpha.
All right, those are admitted.
Same objection, Your Honor.
Overruled.
And permission to first publish 535 Yankee.
You may.
Slack. Hey, get out your motherfucking seat to this one, you know. Slack. 100 rounds in a toe, nigga, lighting up your tacos. Yeah, give them surgery, no lipo. Down, like that bitch will pull you down. Pull up to a nigga town. I'm prepared to take on down. Nigga, hey, did that shine shit. Hey, YSL shit. Hey, kill it 12 shit. Hey, fuck a jail shit. Hey, drink it at the bitch. Hey, on that snail shit. Hey, cook it white brick. Hey, bricks and bell shit. Hey, bitch, I'm super rich. Bitch, I'm stupid rich. I go ape shit. Call that ludicrous. I'm not new to this. Hey, I'm so true to this. Hey, I done put a whole slime on the bitch. Slime with the slime. Man, yeah, don't have a mind. These niggas be bitches, a lot of them snitching, a lot of them dropping them down. I come to the point of my life that I just want one of my wives. I think that I want that new spice. We rich, so I know that it's like this. I'm so true to shit. On some helmet shit. Diamond dancing bitch. YSL VVS. In the VIP. And I got that pistol on my hip. You praying that you live. I'm praying that I hit. Hey, did that slime shit. Need a slime bitch. Compromise shit. Down the ride shit. But the police. In a high speed. Let her out on bleed. Let her out on bleed. 100 rounds in a toe. Nigga, lighting up your tacos. Yeah. Give them surgery, no lipo. Down, like that bitch will pull you down. Pull up to a nigga town. I'm prepared to take on down. Nigga, hey, did that shine shit. Hey, YSL shit. Hey, kill it 12 shit. Hey, fuck a jail shit. Hey, drink it at the bitch. Hey, on that snail shit. Hey, cook it white brick. Hey, bricks and bell shit. Hey, bitch, I'm super rich. Bitch, I'm stupid rich. I go ape shit. Call that ludicrous. I'm not new to this. I'm so true to this. I done put a whole slime on the bitch. Got banana clip for all these niggas acting money. These niggas sandwiches in the street, they need hooked on fun. Got 10 trucks flat, stay bunking, all of them doing on me. They just be talking, I swear these little fuck niggas don't want me. I'm praying up my money and I'm still in the trenches. Working calculators when we fuck with weight, we call them bitches. Got burger, loaf, and true, they with me. I'm real neighborhood. Banging neighborhood 6. Tiny low, still fish. I get it, I get it, I get it, I get it on my own. What? The burger said they got me so high, I swear to God, I'm in my own damn zone. $1,000 on cologne. All of the extras up off of your home. And it's big like the dome. Hold up, country boy calling my phone. And I just sold up. 100 rounds in a towel, nigga, lighting up your tacos. Yeah. Give them surgery, no lipo. Down, like that bitch will pull you down. Pull up to a nigga town. I'm prepared to take her down. Nigga, hey, did that shine shit. Hey, YSL shit. Hey, kill it 12 shit. Hey, fuck a jail shit. Hey, drink it at the bitch. Hey, on that snail shit. Hey, bitch, I'm stupid rich. I go ape shit. Call it ludicrous. I'm not new to this. I'm so true to this. I done put a whole slime on the list. Did that slime shit. Did that mark shit. Did that $100,000 do the charge shit. Down the dial, but they rush it, cut it to my money. They say we getting money, now these niggas acting funny. And they all fake. Like some bitch titties. Tell they bitch another locker, we ain't fucking with them. And they groovy niggas, and they hold tight. For the jail, YSL, let that mall light. We got these bankrolls on us, we in Vegas. Yeah, I ain't going back and forth with y'all. Hello. Yeah, I'm bet me 100,000 tonight, all motherfucking hundreds. Good. Check. Yeah, put me up.
And looking at Stacey Exhibit 535YA, when did this song come out? Or when was this song at least posted on YouTube?
March the 25th, 2016.
And as an investigator and an expert, were there any particular words of note to you as you listened to this song?
Yes.
What were those words of note?
The 100 rounds in the Tahoe.
And why was that of note to you?
Because 2015, the year prior, we had investigated murder of Donovan Thomas where...
Hang on just a second. Yes, sir.
I'm going to object this point. This court, the trial court in this case, has previously ruled that...
Do we need to take this up outside the presence of the jury?
Yeah.
I'm going to excuse y'all for a minute, please. And Detective, I'm going to ask you to step out, please. Thank you. Go ahead.
Thank you, Your Honor. So there's a previous order in this case bifurcating that any expert who would be on the stand in this case, who would also be providing factual testimony.
Oh, yeah.
That would be
splitting out the factual and the expert.
And so, yeah, and this witness is now, she's given expert opinions, which we've heard, but now she's testifying about factual information, and I think that's going to mislead and confuse the jury. And even if Your Honor doesn't believe so, there's a previous order that in this trial we would have a bifurcation of those issues. So I'll object to her testifying about even factual information about what happened in 2015. I also think that I also want to raise an objection because the state has proffered this evidence as something that happened in 2016 when in fact I think the state is misleading the jury because this particular song that they've now introduced to play to the jury was actually recorded 2 years earlier in 2014, prior to any murder of Donovan.
All right, well, you'll be able to cross-examine on that. Can you address the issue of the bifurcation?
Yes,
I
Your
mean,
Honor.
not address the issue. I know that was the order. Address why this is or is not violating that requirement that the fact and expert testimony be bifurcated.
Your Honor, there is evidence already in about the shooting of Donovan Thomas. I believe as an expert, I could simply ask her, I can probably show her the evidence, the pictures of the evidence that we're discussing at this point to make sure that we don't violate her talking about her opinion as to why this song was significant.
Mm-hmm.
I'm thinking through when we have a medical examiner who is an expert, who can talk about the facts of the autopsy and give their opinion as to the cause and manner of death, that this is similar in nature, that she as an expert can speak to specific facts and give her opinion as to why that particular fact is of significance in her opinion. And so that's what I'm trying to correlate it to, very similar to a cell phone expert who can talk about the facts that come out but can give their opinion on certain information. I'm trying my best to correlate how we can do those two things, because I do think an expert can speak of facts and how those facts can form an opinion.
All right, so are we finished with the portion? Has this witness testified to all of the facts that she's going to testify to as a fact witness?
Yes.
Okay. And so whatever you were about to elicit was
information that has already come out, but we're not.
right. I mean, you were getting an expert opinion on something?
Yes, ma'am.
Okay.
If the state proffers that they're going to stick to asking about expert opinions, then I'll withdraw the objection. It certainly sounded like to me that she was asking about factual evidence about an incident in 2015.
Okay, but you're not establishing that fact through that witness. You're asking, why is this fact significant to you?
Yes, Your Honor.
Okay. I don't think that violates that bifurcation order. All right, let's get the jury back and the witness. Is there anybody that knows that we need the jury back? No. I think